viewers, in this video talking to senior advocate Fali Nariman. My question to him is to recall a very unusual occasion in the Supreme Court where a judge asked that the Chief Justice of India should file an affidavit. Now, this mention has been made of this incident in his very famous book, God Save the Supreme Court, and would he like to inform the viewers about this?
Yes. The question brings me to a book that you must read. It's not my book. If you are a student of law and wish to make law your career, this book is called Working a Democratic Constitution. It's not written by me, but it's written by an old friend of mine, an American called Granville Austin. The incident of the affidavit is dealt with in that book.
Okay.
What is of greater significance is the book. It was first published by the Oxford University Press way back in the year 1999, and I had something to do with its distribution. It is currently in the 13th or 14th impression, and it's the most readable and authentic of historical commentaries as to how India's constitution was framed, as to how and why it works, and why it sometimes does not work. It did work well for the first 16 years after independence. In the years of Jawaharlal Nehru, India's first Prime Minister from 1947 to 1964. But with Lal Bahadur Shastri's death in 1966, the Nehru era, as it was called, ended, and then, to quote Austin, a new era, one that would be marked by confrontation over institutional and personal power, began with the arrival in the Prime Minister's office of Nehru's daughter, Mrs. Indira Gandhi. We have not yet seen, Austin continues to write, the end of this new era, because he had written it later, of confrontation that began way back in the January 66. With intimate knowledge gained by living in India for long periods and conversing with people who saw it all happen, Austin's richly personalized account flows effortlessly, pulling no punches, concealing no blemishes, but all in all revealing his apparent affection for India and its people. Austin offers an intense critical insight into more than 4 decades of India's constitutional history. Superbly written, the tome of over 700 pages is a testament of hope, with little thanks to the Ministry of Law, where, as Austin writes, files on constitutional amendments remain hidden by a conspiracy of silence.
Conspiracy of silence. Okay.
That was his view.
Yes.
Ivor Jennings, who was the Commonwealth historian of all the countries in the Commonwealth, his laconic comment on India's detailed constitution was too long, too rigid, too prolix. This he said in a speech in the University of Madras in 1951. Granville Austin, however, saw in India's document of governance 3 distinct strands: protecting and enhancing national unity and integrity, establishing the institutions of democracy, and 3, fostering social reform. Taken together, he wrote, they form a seamless web. But the strands are interdependent. They must prosper together or not at all. So while on Red Austin, who is Professor Granville Austin was always called Red Austin, I must mention that though he is no more, because he passed away in 2014. His inestimable contribution to a better understanding of India's constitution lives on. A graduate in American literature, he started life as a journalist and photographer, earning his doctorate in modern Indian history at Oxford. But he had no legal training. Highly intelligent, with a penchant for hard work, he picked up the law as he went along. After his first book was published in 1966, which is called The Indian Constitution, Cornerstone of a Nation, he received recognition as an authority on the Constitution of India and had become the only non-lawyer to be most frequently quoted in a catena of constitutional cases decided by India's Supreme Court. But to come back to the question you have put to me, in that well-researched book on India's constitution, Professor Granville Austin himself refers to the hearing in the first judge's case, what is known as the first judge's case, S.P. Gupta versus Union of India 1981, where a bench of 7 judges, presided over by the then senior-most judge, Mr. P.N. Bhagwati, in the course of the hearing of that case, commanded the Chief Justice Y.V. Chandrachud, who was not part of the bench, to file an affidavit to explain a challenge in the appointment and transfer of a particular named High Court judge, whose appointment and transfer was questioned. And when that affidavit was duly filed by Chief Justice Y.V. Chandrachud, the presiding judge Bhagwati, in his Constitution Bench judgment, disbelieved its contents, saying disbelieved, saying it was delightfully vague. Professor Austin gives us the reason, and this is Professor Austin speaking. The belief persists that the Bhagwati-Chandrachud confrontation derived primarily from the former long-held grouse against the latter having been made a Supreme Court justice before him.
Chandrachud had become before.
You see, Bhagwati had been senior to Chandrachud in the sense he had been Chief Justice of the High Court of Gujarat, whereas Y.V. Chandrachud was only a sitting judge of the High Court of Bombay. And he believed that he therefore should have been elevated to the Supreme Court before Chandrachud, who had been a puny judge of the High Court of Bombay when appointed to the Supreme Court. So that's how this came about.
Okay. Thank you. We come to the end of this video, and in the next video you would have Senior Advocate Mr. Fali Nariman talking about judicial rectitude. Thank you.